So, I'm gonna report about the basis of political and legal differences. A key theme of this chapter is that inalienable differences exist between countries regarding political practice and legal regulation. As we just saw, intellectual property is a critical component of the development of any economy. No matter how rich or poor, making sense of the differences in attitudes and outlooks, as we would be the case for other political and legal issues, follows from making sense of the effects of historical legacies, economic conditions, and cultural orientation. So, the first effect is historical legacies. Most of the counterfeit goods are made in markets in which the rule of man is a de facto legal system. So, rule of man means that a ruler in whatever form commands authority that is above the law. So, mabalik ta sa case study, a return trip to China, given its legal tradition, its influence, and its sluggishness in protecting intellectual property, highlights the scope of the problem. China has a battery of laws that comply with international standards for market access, non-discrimination, and transparency. However, many Chinese citizens and officials question the legitimacy of laws passed by foreign governments. So, nadaghan ko ng laws nga comply ang China for international standards. But many Chinese citizens and officials question ang legitimacy sa law nga gipasa sa foreign governments. Hence, ang kanang pag-question sa mga Chinese ning create sila og gap between domestic traditions and foreign standards. So this gap between domestic traditions and foreign standards explained by a Chinese jurist means that its intellectual property laws exist to protect Chinese from foreign intellectual property. So this calls for China to protect their intellectual property in the context of rule of law may eventually prove successful. So for China and other countries, the legacy of 2 millennia of the rule of man, or in its current form, the rule of CCP, suggests that such change may be one of the largest social infrastructure projects in the history of mankind. So for China to be able to protect its intellectual property from the foreign intellectual property, then they must change from rule of man to rule of law, since na-prove man nga successful kuno na siya. And if so, that change will be one of the largest social infrastructure in the history of mankind. So basically, in historical legacies, it states here that those countries that observe the rule of law as opposed to the rule of man, more aggressively, more protect sila sa intellectual property rights. The next effect is economic circumstances. The vigor of intellectual property protection often reflects a country's state of economic development. Just as poorer countries regulate less rigorously than richer countries, so too do they more weakly protect intellectual property. So, ang protection sa intellectual property kuno is ma-reflect siya kung unsa ka-develop ang usa ka country. So, in the case of developed countries, ang mga folks nila nga do reason that protecting intellectual property is the best way to energize innovation. If the stuff you create can be misappropriated, noted an analyst, your incentive for continuing to create valuable intellectual property diminishes significantly. Di ba kay kung ikaw mo create ka og usa ka invention and then pwede ra di makuha kay di ka adyo strict ang ilang protection about ingana, di na bidya kaganahan mo padadyon og create kay kanang mawad-an kagana. So generally, poorer countries protect intellectual property less vigilantly than do wealthier countries. The evolving world economy, especially the market, moves powered by emerging economies, alters transnational institutional structures and legal outlooks. So there are popular perspectives in developing countries advocate less stringent protection. arguing that intellectual property rights are better interpreted as predatory monopoly privileges that impose cost through. So, ang kaning mga perspective sa developing countries, muna yung ilang reason na ning advocate sila og less stringent nga protection sa ilang intellectual property. First is stifling the creativity, innovation, and emulation that support technological and cultural advance. Second is inhibiting local development and lowering global welfare by constraining the use of existing knowledge. Third is creating intellectual monopolies that protect business interests, bestow monopoly profits, and lessen the efficiency gains of free trade. Fourth is inflating the prices that poor nations pay for products and processes that are available only from wealthy nations. And lastly, stipulating licensing fees and regulatory burdens that increase the cost of idea creation and slows the diffusion of innovation. So in sum, those five perspectives of the developing nations reasons that property rights are state-created rights or privilege nga mo impoverish siya sa majority in order to concentrate wealth and power among the privileged. So the critics of intellectual property protection argue sila that granting monopoly rights mo impose siya og hardships, mo create siya og inefficiencies, and mo slow pud siya og innovation. So poor people have little money to spend on necessities, let alone for expensive branded goods sold by foreign companies. So of course, sa mga poor countries nga mga poor people maglisod sila og palit og na expensive branded goods nga gibaligya sa foreign countries. So that is why mo result jud sila sa kanang mga pirated. So example ingani is in Kenya, where the average annual income is about $1,800. So it should not come as a surprise that many Kenyans think you have to cheat to survive. So one means of survival is buying pirated copies of products that improve productivity, like for example, software, fight illnesses, medicines, or provide relief or mga consumer products. The third effect is cultural orientation. So we have different attitudes toward intellectual property protection that will reflect our cultural orientation. So for individualist countries such as the United States and Australia, they regard personal property right as intrinsically legitimate. That if you create something, you should have the right to say who can use it or copy it for any given purpose. So ikaw, ug mo create ka og usa ka butang, it means that you have the right for that such thing, and you have the right to give any consent to anyone nga mogamit ingana. In contrast, for collectivist countries such as Korea, Thailand, and China, they extol the virtue of sharing over individual ownership. That if you create something, it should improve the welfare of the society. So, sa mga collectivist countries, ang ila is, if mo create ka og butang, it means that it should be for the welfare for everybody. So, it means that it will be kanang for the free use of the public. So one example of a collectivist country is Korea. Ngayon ang usa ka South Korean diplomat na historically ang mga Koreans kuno wa sila ning view sa intellectual discoveries or scientific inventions as the private property of the inventor or discoverer. Ang mga new ideas or technologies are public goods for everybody to share freely. So, ang ila kuno, ang mga inventions kuno sa Korea, South Koreans, is dili personal property sa nag-inventing na, but for the free use of the public. So, cultural esteem rather than material gain is the incentive for the creativity. So, di material gain, but for the cultural esteem sa usa ka nation. So similarly, there are also other countries nga mo-interpret sila and enforce intellectual protection differently. So one example of this is in 2013, the Indian Supreme Court reaffirmed Indian drug makers' right to apply a process that differed from recorded by the registered owner to produce and sell drugs patented in other countries. In other words, Indian patent law only protects the process by which drugs are made, not the drugs themselves. So, sa India, lahi ang ila. Ang ila is pwede nga mo copy, but it change lang ang process. That is why ang mga Indian drug companies muhimo sila og mga copycat versions of the many of the world's best medicines, and then ibaligyan na nila for much more or less nga price. So one example of it is ang leukemia treatment Glivec, which is developed by Switzerland's based Novartis nga muko siya sa patient up to $70,000 per year. Unja ang Indian generic version ana is about 2,500,000 annually. So dako ka adyo difference sa 70,000 sa kadtong original, unja sa Indian is 2,500 ra, so ang dako agad kadyo. So that is why dili na gadjud kadyo surprising that India is the world's leading exporter of generic medicine. So that is why today technologies challenge the influence of individualism and collectivism in the use and abuse of intellectual property. Among some demographics, whether in collectivist China or individualist US, piracy is an increasingly mainstream behavior. So, kanang bisan pa og unsa nga cultural orientation, whether individualist or collectivist ka, di jud na tumalikay nga piracy mainstream na jud kaadyo. Said the General Counsel for NBC Universal, speaking of illegal file downloading, ang mga young people in particular mo conclude that if it's too easy, it can't be wrong. So munang murag mainstream kaadyo ang piracy kay tungod kay according to the General Counsel for NBC Universal nga ang mga young people kuno mo think sila nga if sayon ra gani makuha dili sayop mao nang daghan kaadyo mga piracy. Improving technologies by making piracy cheaper and easier accelerate the violation of intellectual property rights. So, ang result sa usa ka country para mo improve ang ilang technology is to pirate or mo create og illegal para mo improve sila is di gihapon na siya best good way because it accelerates the violation of intellectual property rights. So all in all, in cultural orientation, ang atong cultural attitudes is mo influence siya sa protection of intellectual property rights. So between the two orientation, ang individualist societies jud ang much more vigilant in protect sa intellectual property rights kaysa sa collectivist societies. So next is the potential for cross-national convergence. As countries evolve from idea consumers to idea creators, they invent products based on their own intellectual property. So at some point, ang mga countries yung cross na sila sa threshold where ang benefit sa protection mo exceed siya sa kanang gains na makuha from piracy. Convincing countries to protect intellectual property confronts a potent mix of legal policies, economic conditions, and cultural orientations. Institutional initiatives try to expedite stronger enforcement. Ironically, calls for stronger protection hinge on the future success of companies in currently lax countries. So, ang history niya shows siya that countries that create intellectual property, no matter the legal legacy, economic status, or cultural orientation, ultimately enforce property rights. So, basically, countries that generate intellectual property is or are strong advocates of ownership Right. So kung kinsa tong mga countries nga mo himo og intellectual property, kinahanglan mo enforce jud sila og property rights. So trends in China signal the start of this process. Along the factory floor of the world, China aims to be the new product lab. Presently, its patent office leads the world in patent applications. So grabe na sila. Of the 2.14 million patent applications filed worldwide in 2011, 526,000 patent applications were filed in China. Yung sunod ang US with 504,000, and then Japan with 343,000, and South Korea at 179,000. That would be all. Thank you.